So the purpose of our lecture tonight is to explore very elementary matters relating to the course. And as I indicated on the platform, you were supposed to have played back the 6 sessions or the 6 episode of the major public lecture, which was delivered on the platform or under the auspices of BBC Reef Lectures by Ian Kennedy, 1980-81. Now, the purpose of that, that lecture is that he sought to explore and dissect key issues which have crystallized into a whole area of law. So that is the purpose. So I wanted you to, so for example, like medicine, a lot of things are actually reserved for the doctors or physicians. And then he sought to challenge the rhetoric of medicine, that most of the things which are actually reserved for the decision making by healthcare professionals are not supposed to be so. But we'll come back to that aspect. But for now, we would like to attempt some definition or delineation of this particular area of the law, healthcare law or medical law. So we start off by saying that medical law is a branch of law that relates to the interaction between law and medicine. And other people use different nomenclature or some alternative labels for it. So some will call it the healthcare law, some will call it health law. In some places, they even call it just simply law and medicine. Now, if you are interested in this nomenclature or these variations in the labels which are given to this particular area of the law, maybe I encourage you to read, I think chapter 1 and 2 of my book, Developing Healthcare Law in Ghana. You could read a bit more about that aspect, that if you want to get more about it. Now, having said that, medical law, however we call it, other healthcare law or health law, concerns itself with also the mediation of bioethical dilemmas generated by healthcare practice. Now, in the practice of medicine, in the practice of healthcare, a number of challenges which are dilemmas. Dilemmas in the sense that, now when I say dilemma, I hope you remember the dilemma of the ghost, Amataidu. Shall I go to Cape Coast or shall I go to what? Elimina? But that's not what we're talking about. But the fact that in the practice of medicine, issues are presented in which the professional, the doctor, the physician, the healthcare professional, is not able to decide whether to go left or to go right, whether to go back or to go backward. Because whichever option that you take, there are ethical difficulties, there are legal conundrum associated with that. So how to mediate, how to navigate these bioethical dilemmas, perplexities generated by healthcare practice, that is the domain of this area of the law we call medical law. Can you confirm if you are hearing me before I continue?
Yes, but we can hear you.
All right, thank you. So, as a legal field, medical law or healthcare law, or health law, straddles between the two major realms of the law. We have the realm of private law and public law. Now, it is difficult to strictly classify healthcare law or medical law as belonging to private law only, or as belonging to public law only. Rather, it straddles, so it shares characteristics of public law and private law. And we see that very soon. Now, the various issues, the various questions which are dealt with in this area of the law draws upon and adapt principles from private law such as tort, contract, property law, family law, and also public law such as criminal law, constitutional law, and human rights law. So the building blocks of this area of the law makes borrowing from these the various subject areas located in either private or public law. So that is what we should keep in mind. For example, one may ask a question, how can we demonstrate that healthcare law, medical law actually makes a borrowing from private law in the sense of tort contract, property law, and even family law? Tort, we'll be talking about the law of consent, we'll be talking about clinical medical negligence, and that will become quite obvious to you. And the ideas from torts are what are actually drawn upon with the necessary modification or tweaking or adaptation to suit the peculiarities of this particular area. Then contracts. Yes, contract too is important because at even the doctor-patient relationship level, you're talking about consent again. And again, sometimes when we need to find out whether there's a course of action for maybe a field treatment or something, like cosmetic surgery and so on, or those who are familiar with the case of a Take and Morris from your law of contract, when you were learning about terms, the couple which went to have like I think the vasectomy with the hope that there'll be no pregnancy again, and eventually they got pregnant and they were not prepared for that, so they sought to sue the healthcare professional, saying that there has been like a breach of contract. So here too, you see that the contract becomes very important. And again, when it comes to property law, we're dealing with the law of organ transplantation. And also dealing with the assisted reproduction. These areas, property law becomes important. In what ways? Questions of whether we can commodify human tissue, organs. Is there proprietary right? Is there ownership interest in organs of a person? So therefore, can you say that your body is for you, your organs, your kidneys, liver, heart, the various tissues, and so on, bone marrow, they are for you. So therefore, you may want to even do some business with part of your organs and say that, okay, by God's grace, I have 2 kidneys and they all function well. And I am told that you can live on just 1 kidney. So I am prepared to sell the other kidney to the highest bidder. I'm looking for not anything less than 1 million Ghana cedis. Could you, for example, put up an advertisement and do that? Now, as to whether that can be done or not, it's all a question of what? Ownership. Is there ownership in human organs, human tissues? And that issues of ownership is properly situated in the area of what? Property law. And again, when it comes to assisted reproduction, when it comes to something like in vitro fertilization, it's also a question of property law, especially sperm donation and then egg donation. You get issues of property here. So that if you donated your sperm, for example, and someone is born, can you, for example, exercise the equitable doctrine of tracing or anything like that, and say that once the sperm is mine, I can trace it to the particular human being who was born out of it or something like that. So these are some of the issues. And then we also have the issue of surrogacy. When it comes to surrogacy, you know that contract again becomes important. Surrogacy arrangement, or what they call the womb renting, by which maybe a woman who does not have a very strong or healthy womb to be able to carry a fetus or baby to the term may need to fall upon another person with healthy and strong womb to carry it. And the contractual arrangements which are made regarding the rights and obligations which the stakeholders have. All these are matters which are situated within the area of contract and also property law. And again, family law. How is family law also important? Family law is part of private law. Issues of consent again. Who is a child? Who is a child? These issues. For example, you come across the interesting case where there was the Gele case. There was a directive by the Department of Health Services in the UK saying that physicians or GPs would give family planning advice and treatment like contraceptive and other things to girls who have attained the age of 16 or below 16, if without telling their parents, if the physician was satisfied that, despite the fact that the girl was no more than 16, she demonstrated sufficient maturity and appreciation of what was involved. And then in which case, it was not necessary for the parents to be contacted. So this issue was taken up by Mrs. Gillick, who had a number of daughters, and she was a strict Catholic, and she could not understand why there will be a policy by the Department of Health, which is equivalent of, let's say, in Ghana, to be the Ghana Health Service, saying that, yes, doctors can give a contraceptive or family planning treatment to girls who are below the age of 16 without consulting their parents, so long as they form a judgment that those girls who are below 16, for example, demonstrate maturity and appreciation of what is at stake. So here, you see how family law is also what important. Just to mention, just by few. And again, so you see how medical law is making borrowing and also adaptation of principles from private law in terms of tort, contracts, property law, and family law. And again, what about public law areas like constitutional law, human rights law, criminal law? How does healthcare law or medical law make a borrowing from this area? Of course, constitutional law, as we know, is more or less the matter of law, all laws, for obvious reasons. So we don't even believe that very much. And again, for criminal law, when it comes, for example, causing unlawful harm, if you remember your law on causing unlawful harm, when it comes to medical procedures and treatment, you notice how the law creates a special exception for medical treatment or procedures. Otherwise, most of the things which are done in the clinical setting would probably be treated as causing what unlawful harm, so to speak. And again, when it comes to even murder and manslaughter, there was a case, the case called the Ray conjoined twins, a very interesting case which was decided by the English Court of Appeal. And the case was this: we had the twins who were conjoined at the pelvic, so that some of their vital organs were somewhat joined together. The assessment and the prognosis was that if nothing was done and they were just allowed to be on their own and they continued to grow like that, eventually both children, that is the twins, they all die. On the other hand, assessment revealed that it was possible to have what they call the surgical separation, to have a surgery to separate them. But then the prognosis of that separation surgery was that if it was done, one of them, they call Mary and Jody, I think one of them was heavily dependent upon the other. And if she was separated from the sister, she could not actually survive. She would die. So this was actually predicted with the necessary scientific assessment. Now, if you go ahead to carry out the surgery, knowing very well that the surgery is necessarily going to result in killing of one of the babies, that is certainly a crime, isn't it? Even if it is not murder, that would be manslaughter. So the facility, the hospital where the procedure had to be done, they were quite hesitant. And for that matter, they had to, of course, the hospital, they wanted to do it, but the parents were also, I think the parents again were religious and probably Catholic or something. And they were maintaining that, well, they are not interested in any separation and they want nothing to be done. Nature should take its course. If they all survive, they survive. If they don't survive, then so be it. Now, so there was that kind of tension, that banter between the parents and the facility. So the facility or the hospital had to go to court for the court to make a declaration as whether the separation surgery could go ahead with the certain prognosis that it is going to result in the death of one of them, and it will still not be treated as an offense, for which reason the surgeons who will conduct it will be arrested later. So they went to court. So here, again, you see how criminal law is also playing out in matters of medicine. And again, when it comes to human rights law is also heavily drawn upon in medical law. Now, most of the things which we will consider as the critical values or principles which underpin, let's say, the doctor-patient relationship, things like autonomy, consent, non-maleficence, beneficence, truth-telling, and all that. Now, when these principles or values are critically examined, you notice that they coincide with a number of human rights enshrined in our constitution, like the Chapter 5, the right to personal dignity, the human rights against torture, degrading treatment, and all that. You cannot really treat a person if the person has not consented, as it were. So, in a sense, you are thinking along the lines of medical ethics and the common law, consent. At the same time, you have a human rights, like Article 15, 15, 14, 16, telling you that every human being is inviolable. The personal dignity, the person should not be subjected to degrading, inhumane treatment and all that. And again, you will come to appreciate that there's something we call the patient charter. So patient charter is supposed to be a unique compendium of rights. And if you look at the Public Health Act, particularly Section 167, which makes reference to the C schedule, a whole range of rights which are supposed to be enjoyed by people who find themselves in a clinical settings have also been provided for. And this is based upon the legislation. So it becomes part of a human rights, isn't it? Yeah. So you will notice that in a very interesting ways, this area of the law is making various borrowing from different areas of the law situated in the public law realm and then the private law realm. Are you with me? Are you following?
Yes, Prof.
Okay. So, what is the function of healthcare law then? Well, from the literature, the ideas distilled, we could say healthcare law or medical law seeks to regulate medical or healthcare profession. That is one. And two, it governs the doctor patient or healthcare professional patient relationship. And thirdly, it defines the bioethical boundaries for medical advances and healthcare practice. And I'll say a few more words here. So, what about medical advances? Now, science is quite dynamic. Science does not stand still. Even as we are speaking now, people are in the laboratory. People are conducting all manner of research and investigation. And in no time, they will make various discoveries which will provide panacea or solution to problems which previously were considered intractable or impossible to solve. I give you an example. For example, until the late 70s, right? Until the late 70s, when we had the first test tube baby being born in the old ham. Infertility or barrenness was considered incurable. And unless you got like in a spiritual way, a miracle or something like that. But with the birth of Lewis Brown, the first test tube baby or IVF baby to be born, infertility in a number of cases have now been diagnosed as a curable medical condition, albeit expensive, but it's there. Possibility is there. Now, the challenge is that medical advances are good. However, they also present major problems with respect to what is acceptable and what is not acceptable. What should be the proper boundaries that should be set in terms of ethical conduct, moral boundaries? Those are the things. For example, there's what we call the designer babies, right? Designer babies, now IVF can be manipulated in such a way that somebody can go to the IVF facility and say that I want a baby who is tall, who is short, who is this, or who is that, and so on. And then they can manipulate, things to get that done. Now, question is that acceptable to society? Is it right for human beings to be reduced into an object, which, just like how things are manufactured in factory, we give specifications. Is it right for human beings to be reduced to that? Does that not detract from our intrinsic worth and dignity as human beings? So those are some of the things. And again, we have, when it comes to organ transplantation, there's something called the xenotransplantation, transplanting tissues, organs from animals, to be implanted in human beings. You take something like pigs. A pig, for example, science indicate that a good number of their tissues and organs function in the same way like human beings. And for that matter, there have been a lot of scientific advancement with respect to transplanting, that is transplanting from these animals to implant in human being in order to let the human beings have health and life. My question is that right? Is society prepared to accept that? So those are some of the problems we have with the medical advances. Again, healthcare law provide or seek to safeguard public health and mental health. So that is one important function. When you mention public health, if for nothing at all, remember the infamous COVID-19, coronavirus 19, and all the threats that it presented. So I need not belabor that it's very fresh to us. And also mental health. Again, healthcare law ensures just an optimal allocation of scarce healthcare resources. Those in the area of economics will tell us that resources are finite, but our wants and needs are unlimited. Now, that observation is very much true when it comes to the area of healthcare. Let's take our country, Ghana, for example. I'll give you one area. When it comes to kidney treatment, right? Dialysis. There are a lot of patients in Ghana that need dialysis, but the dialysis machines and centers are woefully inadequate compared to those who need it. So the question is, who should we give the treatment to? And who should we deny? Again, another function of healthcare law is that it provides governance for beginning and end of life issues. Now, if you are following the news, in the UK, for example, just today, understand by a narrow majority of 23 votes, the House of Commons have voted to approve assisted dying bill, by which those who are terminally ill can be assisted to die rather than they waiting for God to call them. Now, the bill will have to go to the House of Lords for further scrutiny before it could make a final journey towards becoming a legislation. But what is important to us is that should society give the power to anybody to end another person's life? So that is a question. Is it a good thing? Is it right for a law to say that if a patient is in a situation and that patient's situation is said that he or she cannot come back to normal life, and he or she has elected to be assisted to die, should that be adhered to? That is the challenge. That is the difficulty. So issues of euthanasia, assisted dying. Good. Now, having attempted a definition of this area of the law and outline the functions served by this area of the law, would like to come back to do a review of what I gave you. So a review of Kennedy's Unmasking medicine. So now I come back to all of you now. Now, if you remember his work, there's this issue of whether there is imbalance of power between doctors and patients. What did you find from your reading? Listen to him. The question of whether there's imbalance of power between doctors and patients, what did he identify? What did he observe? Then the question of whether there is a potential for exploitation of patients by doctors. What did he say? And again, according to Kennedy, how is the concept of illness problematic? Yes, so these are the issues. Anybody? So if you haven't listened, you go back and then look at it again. I just did something. Let me show you. So in the first episode of his public lecture, Kennedy critically examines the state of modern medicine. He argues that medicine has taken a wrong path, largely due to an over-reliance on scientific methods and technology. So, and this approach, in Kennedy's view, had created a myth that illness can be completely vanquished and death postponed indefinitely. And this has turned doctors into modern day magicians. So those are the kind of arguments that he's making. It's very interesting public lecture, which I hope you go back and listen to. And the book is also there. I also share the written text of that so that you can read it. Either you listen or you read. So Kennedy provide the critique that medical education system for producing doctors, that so medical education concentrate more on producing doctors who are more scientists than caregivers. That doctors are trained just more at just being scientists. And what is the scientific method? You look at the evidence, you just respond to it. That doctors are not trained to be caregivers. And in his view, this neglects the importance of humanities and also preventive care. So Kennedy discusses how modern medicine's focus on curing diseases rather than understanding and preventing them has led to a reactive, crisis-oriented healthcare system. That if you look at the general approach towards how modern medicine is organized, as well as even medical education, how doctors are trained, you will notice that the whole focus has been on how to respond to disease or the malfunctioning body. So modern medicine is more reactive, providing a response to, a reaction to, rather than being proactive or being preventative. Further, Kennedy highlights the problem of reductionism in medicine. And by reductionism in medicine, it means that patients are viewed as a collection of symptoms rather than whole persons. So you identify and classify patients together based upon symptoms that you have observed as being presented by them. And this, in his view, it detracts from the patient as a whole person. So in that regard, Kennedy criticizes the hospital-centric model of healthcare and the increasing reliance on advanced technology, which often leads to an inappropriate allocation of resources. So the first set of his lecture or the episode, that is basically what he discusses. And then the second lecture, which he termed the new magician, Kennedy continued his critique of modern medicine by emphasizing how it has become an illness service rather than a health service. So like modern medicine, like if you like illness service rather than what health service. And he points out the systematic departure from the principles of providing healthcare based on need and the ability to contribute. So Kennedy argues that the political and economic culture, along with the focus on personal health rather than environmental factors, obstruct the necessary improvements in healthcare. So he advocates for reorientation of healthcare priorities towards preventive care and promotion of health. And this includes reducing the reliance on complex technologies and hospital-centric care. So in that respect, Kennedy stresses the importance of primary and community care and suggests that general practitioners should be more involved in addressing social problems and promoting health education. And then he also highlighted the disparities in the healthcare provision among different social classes and calls for political, social, and economic changes to address these inequalities. So these are the basic things that he touches on in the second lecture. Then the third lecture, which he titled Suffer the Children, Kennedy addresses the failures of the National Health Service in UK NHS in meeting its goals, particularly in providing equitable healthcare. So he emphasized the need for political action and social reform to improve health services. So Kennedy discusses the significant impact of social determinants on health, such as unemployment and inadequate social security benefits, which, according to him, exacerbate or worsen health disparities. So he advocates for a greater focus on preventive care, health education, and addressing the root causes of ill health, including poor diet or poor nutrition, smoking, alcohol consumption, and accidents. So he says that these root causes of ill health should be addressed. So Kennedy highlights the critical importance of providing child health and argued that significant resources should be redirected towards prenatal and postnatal care, as well as childhood nutrition and education. So he provided a critique of the current state of children's health services as at that time and called for comprehensive political action to ensure better health outcomes for future generations. So that is the bit of like a summary of what Kennedy did in that particular lecture, which I have sent and I've shared this thing with you. And I expect that those who have not able to play it, you can make effort and then play it so that you add it to your general appreciation of the area. Let me share this screen again. Hey, is medical ethics the same as morality? These are questions I would like you to keep at the back of your mind. As I give the literature to you and you read, you come back and address them. And I also like you to identify and explain some of the key approaches to medical ethics. And then we need to find out, is there any relationship between healthcare law, medical law, and on one hand, the medical ethics and then bioethics? Good. So bioethics is an analytical activity in which concepts, assumptions, beliefs, attitudes, emotions, reasons, and arguments underlying medical legal decision making are examined critically. So, at one level, the purpose of philosophical medical ethics is simply to make such decision making more thoughtful and intellectually rigorous. Its ultimate purpose is to construct and defend a comprehensive and a coherent moral theory for medical practice based on universal principles applying to all incapable of justifying particular lines of conduct in individual cases. So, in practice of medicine, healthcare, whether we like it or not, there are a number of dilemmas, and these dilemmas prevent difficult questions, ethically or morally. What is the right course of action to take? So, for example, you are a healthcare professional or you're a doctor, and you have identified or you have spotted something from various investigations you are doing on your patients. But you know that the patient that you have are not actually take in certain things. Either the patient is very anxious, paranoid, and so on. So should we make the disclosure? Or maybe a cancer you've discovered or something like that? Or should you keep quiet about it? This is a difficult situation. Or let's suppose that you are a physician. You have a patient that you have diagnosed as being HIV positive. Should you, tell the patient to go and tell his or her sexual partners, or what? So all these are more important, particularly so when the law is ambivalent or does not address the issues at hand at all. Now, where the law has provided guidance as to what should be done, that one, as somebody said, the law is the law. We just follow what the law says. But where the law is silent. And yet, the scenario presented from our own instinctive appreciation, we realize that something ought to be done. And the question is, how do we navigate that kind of conundrum, that kind of difficulty? So as we move on, you will notice that there are various ethical approaches. Major ones, utilitarianism and deontology provide framework which guide us regarding how things should be done. So this is very introductory. We come back to them again, but as part of the general introduction we are doing, with respect to utilitarianism, it basically refers to a theory of ethics which is concerned with maximizing welfare. In other words, utilitarianism sees something as worthwhile, something as good, or something as ethical, if it can create happiness, greatest happiness for greater number of people. It can maximize pleasure for greatest number of people, or it can minimize pain for greater number of people. Then, according to utilitarian thinking, such an activity or endeavor is worthwhile or is good. So classical scholars behind utilitarianism include Jeremy Bentham, J.S. Mill, and they use what they call the pleasure and pain in a broad sense that allowed them to include achieving what one desired as a pleasure and the reverse as a pain. So the pleasure pain lexicon is just a convenient way of trying to make a determination as to whether what is gained from an activity or what is avoided from an activity can be considered as good or bad. Now, the ontology, on the other hand, comes from the Greek word dion, meaning duty or obligation, and logos, which does not have literal translation, but in this context, we can mean discourse or study. So the ontology is a theory of ethics concerned with rights and duties, and it is to the effect that rights, duties, and obligations have a commanding force of their own, regardless of the consequences. So they have intrinsic or inherent or innate appeal on their own. So rules, once formulated, are categorical in deontological thinking rather than hypothetical. And deontological reasoning should take no account of desires or wants and permits no deviation from those rules. So deontology is often associated with moral absolutism, that is, the moral viewpoint which does not accommodate exception, which does not accommodate derogations. The view that there are obligations to which there are no exceptions. So for example, when it comes to something like a sanctity of life, if you take the view that life is sacred, then we have sanctity of life. Then the ontological thinking will say that under no circumstance should life actually be destroyed, or the sanctity of life principle should be undermined. So one of the proponents of the ontology is Immanuel Kant, and he argued that there is a single principle or rule from which all other rules can be derived. So he talked about what we call the categorical imperative. Okay, so right now, because you are here to do the reading, I think because this lecture, I usually run it on the assumption that my students who have done some pre-lecture reading, and if that had been done and we had finished that, then we have gone on to our next class. We have gone to the second part of this, but as it is now, I intend to stop, and I'm going to send you all the materials that I've indicated. And I would like you to go through this before our next class, and then play what I ask you to play so that you are able to participate as I would like you to do, so that the class will be more interactive for the level that we are having it.